People from all walks of life approach me with what I can only describe as a profound sense of pride. They stare at me as if to say, "Look at what we've done."
Being in the audience for that speech, I'm telling you, the place exploded. Justice Ketanji Brown Jackson speaking at the Library of Congress on Friday after attending her investiture ceremony to officially begin her tenure on the Supreme Court. Justice Jackson joins the court after the most consequential term in modern history following the fall of Roe. And the next term may be even more impactful. The first Monday in October always marks the start of a new Supreme Court term, and this term's docket is filled with major cases, from affirmative action to what remains of the shredded 1965 Voting Rights Act. Joining me here in studio is the former Democratic senator from Alabama, Doug Jones. He also guided Justice Jackson's confirmation through the Senate. Senator Jones, welcome back to the Sunday Show.
Thanks, Jonathan.
So you were at Justice Jackson's investiture at the court on Friday. You had such an intimate role in guiding her nomination through the Senate. What was the investiture like for you?
Well, it was very short and sweet, very scripted. But the fact of the matter is, it was just an incredibly emotional moment to see her come into the courtroom, actually sit down below the dais initially in the chair that Chief Justice John Marshall used from the bench. They had gotten it out of the display case, and she sat there, and then the Chief Justice called her up to see her to ascend to the dais. And it was just an emotional time, just an amazing experience.
And as you said, that ceremony was very quick. She didn't really get to speak at all, except what were the only words she was able to say?
Other than repeating the oath of office, the only thing she said was thank you to the Chief Justice when he welcomed her.
And I bring that up because I then saw you at the Library of Congress celebration a few hours later. Talk about the significance of what happened there.
You know, it was a wonderful celebration. There was music. There was a discussion about Justice Jackson's hero, Constance Baker Motley, who was the first black female federal judge in this country's history. But her speech was just remarkable, and it showed the kind of inspiration that not just her nomination has become, but she has become to the American people and to some millions of young people, and particularly women and women of color across this country. And it was just an inspiring, emotional afternoon. It really was.
It was a phenomenal speech, and go to the Library of Congress website because it lives there. You can watch her speech. All right, the senator. A Gallup poll during the fall of Roe v. Wade, the Dobbs decision, showed only 25% of Americans have confidence in the Supreme Court. What kind of court is Justice Jackson walking into?
Well, I think she's walking into what appears to be a Clarence Thomas Samuel Alito court. It doesn't appear that Chief Justice Roberts has the same kind of control as the Chief Justices in the past. This court seems to be more concerned about agendas than they are the rule of law. That's my view, and I know there will be people that disagree with that. But what we've seen over the last few years is that precedents keep falling. I think we're likely to see some more precedents falling this time because these justices don't like affirmative action. They don't like the Voting Rights Act. They don't like those things that have been staples of the American psyche for the last 50 years.
Well, let's talk more specifically about affirmative action, because during her confirmation hearings, then nominee Jackson said that she would possibly recuse herself from the Harvard case involving affirmative action. But the Harvard case and the University of North Carolina case that was attached to it, they have now been cleaved apart.
Yeah.
So should Justice Jackson still recuse herself from the Harvard case? And what should she do when it comes to the North Carolina case, do you think?
You know, Jonathan, that was perplexing to me when I read that, because the issues, as I understand them, are the same. And it's going to make for some interesting. And what I worry about is that the decision has already been baked in, and her vote is going to be an inconsequential vote. I hope that is not the case, and I hope that she will, in listening to and participating in North Carolina, maybe try to just influence the affirmative action cases in general. That's the only way she can do it. But it's going to be interesting to see how the two of those turn out, with her being participant in one and not the other.
And let's talk about voting rights, or whatever remains of the 1965 Voting Rights Act. Listening to your previous answer, it seems to me you think that we're about to see the end of that historic piece of legislation.
I am extremely worried about the voting rights. This court majority has already shown a propensity to strike down voting rights and do things that are clearly designed, in my opinion, to give a preference in voting to one political party. There's a couple of cases that are out there. One's going to be heard on Tuesday from Alabama, redistricting case in which 2 Trump judges decided that the gerrymandered legislature that we've got in Alabama overstepped their bounds and that Alabama should have an additional majority-minority district. That case is going to be heard. We didn't have it. They stayed the decision so they could hear that. Worried about that case. Number 2, and the one that concerns me the most out of all the cases right now that are pending, is the one about this independent state legislature theory out of North Carolina again. If that happens, Jonathan, then they give state legislatures in this country carte blanche, just absolutely blank check to do what they want to do. Then I think that democracy is not only in peril, democracy is on the downhill slope in a big way.
So then that has implications for other stuff that we're talking about, like the slate of electors and things like that when it comes to...
There's no question. This independent legislature theory, there is in the Constitution where in Section 4 that the founders gave legislatures theory. But you have what this case is basically saying is that they have no checks, that their state courts in North Carolina or Montana just issued a ruling recently, have no authority, that the legislatures have the final word in how to conduct federal elections. And that's frightening given the gerrymandering that we've seen and given the propensity of legislatures now to basically say, you know what, if we just don't like these elections, we'll just do what we can to overturn them and forget the will of the people, forget the elections, forget the free and fair votes of the people. We'll decide what's best. And that's really frightening for democracy.
That is frightening.